Okay.
Okay. All right. Hi, my name is Ken Vercammen. I'm an attorney in Edison, New Jersey. I live in South Brunswick, and periodically we have programs to help the public on giving information on wills, probate, powers of attorney, things like that. And so in a way, it's important because we always say, hey, we need a call to action because there's no one selling life insurance in hospitals or funeral homes. You want to get things done because it's for the benefit of your family. Oftentimes people will say, Kenny, why do I need to have a will? I'm married. Doesn't everything go to my spouse? He goes, well, yes and no. That's not doing planning. That's just hoping that one of the two of you lives forever. The idea is what's gonna. You always got to think. Okay, if this person passes away, who gets their share? If this other person passes away, who gets that person's share? We've done events with the Surrogate, and the Surrogate is amazing. A number of people don't have wills because if you have no will, or your will is declared invalid because it was improperly prepared or not admissible to probate, the procedure to distribute assets becomes much, much more complicated. So let's say there's if there could be 3 children, all the children have to sign, a document that they pick one person to be the administrator where there's no will, and the people who aren't going to be the administrator have to sign a renunciation. Their renunciation has to be signed in front of a notary, filed with the surrogate for a fee, and that's in cases where everyone agrees. Let's say sometimes you get matters where everyone doesn't agree. Well, what that means is that there has to be a complaint order show cause, and a Superior Court judge has to determine who's going to be the administrator. Whenever you go in front of a Superior Court judge, plan on spending $3-4 grand, and certainly having a will costs substantially less than that. Also the surrogate's office will often, in their programs say the problems they see all the time is people try to do cheap things themselves, these online forms, and they often typically do it wrong. Also, if there's no will, the will isn't done right, there's an additional expense called a surety bond. The administrator has to take out this insurance policy. It costs $1,000 or more and per year, and they don't get the money back. That's the money paid to the insurance company. If there's no will, state law determines who gets your assets, not you. And more people are saying, you know what? Let's see, my kids are already okay. I'd rather leave the money towards my grandkids to pay for college, to pay for weddings, things like that. My daughter's getting married in 2 weeks and 3 days, and the cost of these weddings is astronomical. The cost of college is astronomical. So some people say, listen, why should my kids already have a house, but I'll put it for my grandkids. By not having it, but the most important thing people got to think of, when you don't do any planning, it often causes aggravation, sometimes fights and lawsuits amongst the family, and you're kind of creating a problem down the road. It's if you didn't put oil in your car for a year or two, you're not really saving money. You're doing something that's dumb. So think about who do you want to get your assets? Who do you don't want to get your assets? Let's say when loved ones are grieving, there shouldn't be one more thing they have to worry about. If you have minor children or minor grandchildren, okay, what age should they get assets? Because remember, 18-year-olds don't do smart things with money. By the way, the procedure for doing documents, in a way, became much easier after COVID, closed everything down, because the old system used to be you would schedule an appointment, you take off half a day, drive out there, then they'd give you a clipboard, and you take a pen and start filling things out, and people had to figure out, how person's last name is spelled, how the beneficiary's last names are spelled, the executors. Well, the easier way we found out to make things easier for most people is we would email a short questionnaire out. Let's see, that way at their leisure they can type in who's executor 1, who's executor 2, who gets your things if that person passes away. And who don't you want to get your things. So let's talk about how the process works on easily getting a will done. The questionnaires, typically you type in your name, and then you're typing in who's going to be executor one, who's going to be executor two. And by the way, sometimes some people don't have email, some people don't type. Hey, that's fine. Their kids help them, their grandkids help them. It's just that for the conflicts of interest, we have to speak to the person directly and make sure that that's what they want, not what their kids want. Okay. You have an executor one and an executor two. You never want to have joint executors. It's creating more work. There could be twins living together, but that means that two people have to sign go to the surrogate. Two people got to sign every check. Two people sign every contract. Two people got to meet with the realtor. Two people got to go to the closing. Why create more work? And that's where people get along. Sometimes you get people who don't get along. We had a probate matter in Ocean County, and these two brothers they couldn't agree upon anything. They're fighting over couches and dumb stuff. If the one brother said the sky's blue, the other brother would say, no, the sky's gray, you're stupid, and you've always been stupid. So that's why there's one captain of the ship. You want to have an executor one, and you want to have an executor two. Make it as easy as possible. Don't give more work to the family. Now, believe it or not, New Jersey did away with some taxes. New Jersey did away with the New Jersey estate tax. And for inheritance tax, there's no tax if it's going to children, grandchildren, stepchildren, spouse, parents. So that's why we don't ask a lot of questions regarding assets, and assets are not listed in the will unless there's a specific bequest. Basically, most wills say, listen, if I pass away, the assets are divided. Whatever I have on this day, when I pass, that it's divided this way, this way, this way. A fellow recently said, you didn't list any of my assets in a will. And I said to him, I goes, well, I need to know the day you're going to die and what you're going to own on that day. And he goes, I don't know that. He goes, that's why we don't list any assets. And now, even if you have a will and it's valid, done by an attorney, there are certain assets that don't pass under the will because they pass directly to a beneficiary. So assets that pass by title are things such as a house on husband and wife, bank accounts payable upon death, joint tenancy, with right of survivorship. Certain assets pass by contract, IRA, 401k, life insurance, annuity, who's ever the beneficiary, that's who gets it. A will cannot change that. So it's also important that you make sure you make sure 100% that the person who is that you want to get, if it's a specific account, do it. If you're not sure, get it from the bank. Okay. Now, I mentioned you're listing who's getting your things, and if that person passes away, who gets their share. Some people also have what's called specific bequests. Specific bequests might be particular items. Some ladies say, I want my jewelry to go to my granddaughter because they know if their son is the executor, he's going to bring it to cash for gold. He goes, what do you give me for this stuff? Some of the men, they have their prize, like Joe DiMaggio autographed baseball or something, and they wanted to go to someone. Some of the men have firearms. You got to go to someone who has a firearms license. Some people have specific bequests, of money to a church, a charity, any type of nonprofit. For example, the South Brunswick Library Foundation is raising funds, to build upon the Kilmurray building. So someone could say, okay, listen, I'll leave it, $1,000 here, $2,000 to my church, etc. Some people also have what we call the reverse specific bequest. That is, I leave nothing to this person. You don't leave them $1. You don't put a reason, just nothing to them. Because remember, that is your right to do with your money what you want. Recently, a client, said, do I have to leave everything equally to my kids? I goes, no, that's your right to do with what you want. What's your concern? She goes, well, I got 4 kids, but one of them, lives on the West Coast. We don't hear much from him. And he goes, well, let me ask you a question. Did you get a card or a call, even a call on your birthday, Christmas, or Mother's Day? She goes, no. He goes, then don't leave the guy anything. Why should you reward someone that doesn't care about you? And my office also recently handled a matter where we didn't do the will, but this lady left her assets to her sons. She had two kids. One died. She left it to the son who died. Later on, to his widow, because she was nice. She was nice to them. She did the will herself, and then the grandkids go and challenge the will down the road, and the judge points out after reading our brief and looks at, okay, these grandkids don't visit grandma, don't see her at all for 8 years. They live a couple towns away. They're not calling her. They don't care. So all of a sudden, once they're not, I go, where's my money? Well, the law rewards people who are good people. Also, you want to have a clause that says monies don't go to kids. And we usually put, if there's minor kids, they don't get any money outright until they're 22, 25, and 30. However, as much money as is needed can be spent for college, for education, maintenance. So rather than just giving them a lump of money where they would probably go and have parties and go to Seaside and buy a red fast car and goof off. So the idea is, you pick someone in the family to be a trustee of the money. If you have minor kids, they don't have to live in the United States. We've done plenty of wills where guardian number one is someone living in India, because my clients that's where their family's at. They don't have anyone in the U.S. They just don't want to knock on the door of a neighbor and goes, hey, listen, can you be the guardian of my kids in case both of us something happens to both of us. And for some people, that's the toughest decision, who to be the guardian. He goes, no, let me help you out. That's going to be an easy decision, okay? Who don't you want to be the guardian for your kids? Well, there's not too many people left on the planet, and a will can be changed, as often as you want. One of our clients used to updo her and revise her will every year, depending upon her relationship with her one daughter. 1 year the daughter's out, 1 year the daughter's back in. I mentioned the part about monies into a trust. The trustee can expend as much money for college maintenance support. Let's say the person graduates from college and says, hey, Uncle Raj, listen, I graduated college. I got a job offer. It's in Texas. I thought it'd be a good idea to buy a condo there rather than just renting. And Uncle Raj could say, okay, that makes sense. On the other hand, the kid's 20 years old. He goes, listen, I'm dropping out of college. It's very stressful. I need some money to take a trip across Europe. Well, the trustees could say, no, your parents didn't work hard, so you can goof off and quit school. Some people set up trusts when they're in second marriage situations, or even first marriage situations where the spouse is not in good health. Rather than leaving the money to them, it would be set up it's called a testamentary trust, and that way, if the money is put into that trust, that money there for that spouse is protected from Medicaid. But I previously mentioned you got to be careful to make sure that everything. You could have the best will, but if everything's automatically going, IRA, bank accounts, a house to someone, then the will can't override that. The trustee's the one who holds the money. The guardian's the one who holds the kids. Sometimes we've set up trusts where one of the kids is, hey, they're adults. They're 40 years old, but they're alcoholics, or they have financial problems, or they'll just blow the money. So we get another family member that's going to be the trustee and make sure their bills are paid and help them out. Now, if anyone's taking notes, I also mentioned you want to have what's called a self-proving will. Self-proving will. What happened? The way the wills used to be, under the law, there was a person signs and there's two witnesses, the person signs. Okay. Well, then one of the witnesses had to go in front of the surrogate and sign papers to say they were the witness. And it sometimes was difficult finding the witness. And when my grandma died, the one witness we found, she goes, oh, I want $500. $500. So the self-proving will statute has provisions that avoids having to find the witnesses. So the person signs, two witnesses sign after that, then the attorney or notary. Then there's another page with language under the uniform probate code. Person signs again, the two witnesses sign again, the attorney signs again. That way down the road, the executor does not have to locate the witnesses. And that's another reason why the surrogate tells people beware of these cheap online forms, because it doesn't have language that says, the self-proving, so they got to find witnesses. You also want to make sure that there's a clause that says in the will no bond is required. All right. You also want to advise the attorney, are there any beneficiaries that are receiving disability, like SSI, SDD, whatever, or reasons why they should not receive the money outright. If someone's receiving Social Security benefits, then sometimes there's reason why they shouldn't get the money outright. There are new laws that permit an account to be set up for that person, but they can't be just getting the money outright. Okay. The short interview form is sent to the attorney. Then again, I've tried to make it easy for people, so that they can, I can call them up and say, okay, I read your paperwork. Here's what I suggest. This, and this. Okay, fine. People pay the attorney. They send it a check. They do the credit card. My wife's been the bookkeeper where she can have it set up where people do the credit card through LawPays, and then we prepare the documents. We found it. We also try to be environmentally friendly. Trying to do things as touchless, remote as possible. We email the documents to people. Most people have a printer at home. We say, listen, print the documents, read through them, and then we'll talk again. You can also email me questions, because I'm very good on getting back to people. I have that great hands-free thing in the car, so you're driving, and on the steering wheel I could say, Siri call, etc., 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 and I still got two hands on the wheel, and I'm calling everyone up. Let's see, there's also revisions where people don't even have to go into the attorney's office to sign. It just has to be signed in front of a notary and two witnesses, and the spouse can even be a witness. So people, what happened during COVID when stuff was closed, people were going to the UPS stores with, two witnesses. You put your germ mask on, and you got your, once you sign, remember, the original will is your property. Only the original will can be admitted to probate. A photocopy, but by the county surrogate. Now, think of the surrogate as a fancy name for the will clerk. The surrogate can only admit a will where it's the original will with the original signature, proper witnesses, etc. Probate, by the way, in New Jersey is probably the easiest in the country. If someone passes away, all you need to do is, the surrogate needs the original will, death certificate, check for about $160, and their information sheet. And what we've done to make it easier for people, we once people type up their stuff, we fill out the information sheet. I email it to the surrogate's office. They assign it to one of the the deputy clerk, surrogate clerks, and then they'll email me the paperwork. The people can sign in my office. They can sign in front of a notary, and then we got to send in the original will and information, and then the people get their letters testamentary. Pretty easy. And that's for the majority of the people, that certainly beats driving to New Brunswick, thinking you're going to find a parking space, which you're not going to do, and then trying to go into the parking deck, which is circular, and you see where the people that weren't familiar with it are, all these gouges and smash marks into the wall because they're going up the circular, parking deck, and then you got to take the elevator down, then walk up a big giant hill to the surrogate's office, and there's no handicap parking that's at the courthouse. You got to park a block or so away, and then still go up this big hill. If you try to park, it's interesting, these movies where everyone can just pull up right next to whatever building, the federal courthouse, just pull right in front. It goes, forget it. You can't get close to park to any of these court. If you do try to do that, in the sheriff's office is going to have your car towed away. Where should you, once your original will is signed, it's a good idea to I mentioned only original will can be admitted to probate. So you want to make sure that your executor has access to the originals, or can easily access it. So you don't want to put it into a safe deposit box. Now, also, many of the people that are employed have what's called a legal plan. So the two biggest legal plans in New Jersey are MetLife and IROG. There's another plan that's called Legalese. Some of the retired auto workers have coverage through the UAW. But I put in the chat button a sample of some of the companies. You talk to human resources, because why would someone want, people are saying, I didn't realize how easy this was, like everyone should do it. Yeah, everyone should do it. Oh, and by the way, like I always mention that typically most attorneys charge a consult fee for you to talk to them. My office, if someone attended one of our seminars, then if they contact us within 30 days afterwards, we don't charge them on the consult fee. Having wills is much, much less expensive than having documents done. If there's a child with certain disabilities, some people set up what's called special needs trusts, but most people don't need something that's really, really, really sophisticated. A will is good forever. However, there's a difference between what is valid and what is best for someone. So, a will that we do here in New Jersey is valid if someone moves to another state. But there's a difference between being valid and what is best for someone. Now, let me just switch for a second and talk about trust. People say, call, I want to get a trust done. My mother-in-law used to call every other year. I want to get a trust done. I want to get a trust done. And I would say, were you watching Susie Orman on TV? And she'd say, oh, yes. I goes, well, Susie Orman is right. If you live in New York, California, Florida, where the probate process is very, very, very complicated. But New Jersey is the easiest probate state. So I ask everyone, okay, please explain why you want to spend between $3,000 and $6,000 not only setting up a trust, but transferring your assets into a trust. Because just having a trust doesn't do anything. It's having the assets owned by the trust. And the answer is oftentimes, well, my friend I watched Susie Orman, or my friend in Florida did it. Now, if you live in Florida, California, New York, if you don't have a trust, you're insane, because you're creating a hassle for your family. There's two kinds of trust. One is called a revocable trust, which is very popular in Florida, New York, California. Some people want to shield their assets from Medicaid. That's called a revocable trust. That means that your assets are retitled. They're not owned by you. They're owned by the trust. And then you got to wait 5 years before you apply for a nursing home, and you can't be the trustee. But whether or not you go with the trust or with, you always want to have a will, because there's always assets that weren't retitled in the name of the trust. But, get the things done. You don't need to read about these kind of things. Next week, start the process rolling. You don't need to study on stuff. There was this client that, or it wasn't a client, let me tell you. Fellow came and saw us, and this fellow was an engineer, and he was very meticulous and very thorough when we go over what we recommend, because his estate at the time would have been subject to estate tax. And he's like, I want to read up on this. And I go, Carl, you don't need to read up on this. I've read for you. I went to law school. I passed the bar. I've been doing this for 30 plus years. I attend seminars all the time. I wrote a book on this. Well, I want to read up. Well, Okay, 2 years later, the guy dies. His family calls me up. He goes, "Oh, we found some of your papers and your brochures. Do you have his will?" I goes, "No, he never. He wanted to read up on it. So it ended up costing the family thousands of dollars more. You're saving money by doing stuff and doing planning. Also, why does someone not really need a trust in New Jersey? Well, probate in New Jersey is easy and expensive. Again, you're having, people, you're usually the fee on having trusts is $3,000. The trust salesman, say, probate is the devil, avoid probate. Yeah, in other states, but not in New Jersey. A revocable trust does not protect assets from nursing home. It doesn't protect assets from creditors. It doesn't protect assets, from taxes. The trust salesman also say, well, a will is a public record, but your trust is private. Well, most people in their will, they're leaving their assets to their family. Maybe if someone's a kook and they're leaving their assets to the Ku Klux Klan or something like that, but other than that, and if it's a house, the transferring ownership of the house is not a quick transfery thing. It's not like signing the back of a car title. Transferring a house requires a deed, seller certification, residency affidavit. You're paying about $150 for the recording fee. You need the cover sheet, the affidavit of title. And again, I ask people, why do you want to do this? Now, if someone just doesn't want to own the house and they want to guarantee it protected from Medicaid, I said, okay, that's an example where I would recommend you set up an irrevocable trust. Don't just sign the house over to your two kids. And he goes, why? He goes, okay, number one, the kids get a low basis, whatever you bought it for. But also, if one of your kids passes away, then their spouse now owns the house, and they can possibly kick you out. So it's a little bit more complicated. Let's see. Once after we sign documents, or the person signs the documents, we recommend that they scan each and every document. So we recommend that they scan the will. They can make sure they send it to the executor. Although a scan will is only for informational purposes, you want to either have them hold the original will or let them know where it's at. We recommend they scan the power of attorney and email it again to each other. In email to their financial advisor, their accountant, any person that has money, to say that, hey, we're letting you know ahead of time. This is the person who is the captain of the ship. And the living will, we recommend people scan it, send it to the family, and then send it to the doctor. A will does not need to be updated. If your beneficiaries and executor remain the same. However, you got to look to see, down the road, can the executor still do the job? We do recommend that a new power of attorney be signed every 5 years, or if the person that you've picked, if changes, or if their name changes. So an example of that is, someone has their daughter as the power of attorney. The daughter gets married or unmarried, the name changes, and the address changes. Well, that's going to be it's better to have a new one signed, because otherwise it's a project trying to convince a bank. Someone brings in a power of attorney to the bank, and the bank says, well, who's this? The power of attorney form says, Brenda Jackson of Gardenia Court is the agent, and you're someone else, and you list someone else, and the person might say, well, I moved, I changed, I got married. So talk to a professional. Let me talk a little bit more about powers of attorney. The power of attorney is the document that you're giving the instruction. You're permitting someone you trust, spouse, child, trusted person, the ability to act on your behalf legally. To be able to sign your checks, pay your bills, transfer real estate if necessary. But it's another document that beware of these cheap online forms, because what was happening was some of the Wells Fargo and some of the institutions weren't honoring a perfectly good power of attorney. And what was happening was they, oh, it wasn't Wells Fargo, oh, it wasn't done in our form. You know, they were very difficult dealing with the family. So the legislature came out with a law that says if the power of attorney makes reference to New Jersey statute, they have to honor it. But that means the power of attorney has to reference Section 2 of PL 1991 C 46:2B-11. And I'm pretty sure that these cheap online documents don't have reference to New Jersey statute, and the bank's going to give you a hard time. If the power of attorney is not valid, or if there's no power of attorney, then the family has to go through a complicated and expensive guardianship proceeding. So it's kind of, we get a call once a week. Oh, I need to get power of attorney over mom, dad, Uncle Joe, wherever. It goes, you can't get power of attorney over anyone. You have to affirmatively, have the person. They have to speak to us and say, yes, I want to have a power of attorney. I want this person as the number one. This person's number two. If I can't speak to the person, I can't do the document. Period. I either do everything right or I don't do it at all. We all, and we've revised our power of attorneys over the years. We've added in our clauses for under the HIPAA law, under the Pulse law. Last year, we added in someone to be the designated caregiver under New Jersey Act. Now, a power of attorney is effective either right away or only upon disability. We recommend that the power of attorney be effective right away because why put things off? Get things done. Because if it's effective right away, the person can act right away. If it's effective only upon disability, you need notes from doctors and to satisfy a bank, and some of the bank might say that doesn't satisfy us. If it's effective right away, they have to honor it right away, and if they don't, then you can file a complaint with the Department of Banking, and then they get in trouble. A power of attorney is effective right away. It's called a durable power of attorney. It's effective now, stays durable if someone becomes disabled. A springing power of attorney only springs in effect where someone is disabled and there's a note from a doctor. My client last year, Fred, goes, Kenny, he goes, listen, I'm a carpenter. I don't understand this legal stuff, springing and durable. Explain to me, please, in carpenter terms. Okay. If it's effective right away, your son who has the power, you gave the power of attorney to, effective right away, he can steal all your money right away. If it's effective only upon disability, he has to get a note from a doctor before he steals your money. Knowing that, you trust your son. He goes, oh, I trust my son with my life. Good. Just make it effective right away. Some people are stubborn. No, I only want effective upon disability. I had a 99-year-old guy. He was so bad of eyesight. He didn't want to be called blind. This guy couldn't see anything unless he had one of those jeweler's glasses where he's looking. Here's this guy reading his documents with the jeweler's thing, and he read every line, but he said, only upon disability. He goes, told the guy, listen, you're the definition of disability because you can't drive, but that's what he wanted. But it's better if it's effective right away. All right. The last document we're going to talk about is the Living Will Advance Directive. People have all in New Jersey heard about, the Karen Ann Quinley case and the Terry Schiavo case, and it went all the way to the Supreme Court where, can you remove life support, etc. Well, really, the Living Will Advance Directive, medical proxy, isn't even for you. You're the sick one. As long as you can talk for yourself, you make your own decisions. It's really someone's in a coma, irreversible condition. You're giving instructions to hospitals and doctors. So you want to take the pressure and the burden off them to try to have to make that ultimate decision. Because, hey, I remember a doctor asked for someone who did not have a living will. The doctor asked me the ultimate decision. Hey, should we remove life support? Now, and I'm like, geez, doctor, I feel bad. Now, what the right decision is for someone who's, 92 years old, that's never going to regain consciousness, it's never going to open up their eyes. But you feel bad being the one to say, okay, ended today. I couldn't even do it for my dog when my dog was so sick. My first dog, I had to send my wife in to do it. So the idea is preventing that kind of situation. That was in the old Terry Shovel case where the family's fighting over what to do. You're making the decision. So what are the decisions to make? Well, what we've learned to do is we took some of the language from the State Medical Society. That way doctors are familiar with it. So first section 8, fluids and nutrition, to be withheld or provided. Well, nowadays, 85% of people say, listen, if I'm a coma, there's no hope for me coming back. Then they always say, no feeding tubes, pull the plug. Now, we're not talking about, some people were worried saying, well, what if I have a heart attack when I'm at ShopRite? Does that mean that they're just going to, not do anything? No. It's really where someone's in that kind of irreversible condition. Section B of the living will deals with directive as to medical treatment, artificial machines, etc. Nowadays, 99% of people say, hey, listen, if there's no hope for me, I don't want to be kept alive by machines. And then at the end, my family gets stuck with the deductible. In the power of attorney, your power of attorney, you're having someone to be your agent, similar to in a will you have someone as the executor. In the living will, you have someone as your agent, your attorney in fact for medical clauses. It can be the same person or it can be someone different. In some families, what they'll do is they'll say, hey, listen, this person is very good with money, with finances. I want to have them be the one to be the agent. On the other hand, for the living will, they might have a different child that is more familiar with medical things, so they have that. But it's whatever you want. But it's you want someone that is definitely going to follow your wishes. And it's funny because I've been married for 30 plus years, and when you're first married, you're all lovey-dovey. And I remember I'm redoing my documents, and my wife says, oh, if something happened to you, I could never let them pull the plug. He goes, okay, fine, I'll just leave my dad because he's logical like Mr. Spock on Star Trek. So then 25 or so years in the future, my wife's like, okay, wait, we're updating documents. She goes, okay, if you die, I get $850,000 tax free. I can retire and never have to work again. Well, why can't we pull the plug on you now? I'll just get the money right now. I joke sometimes the way with life insurance. I goes, having a lot of life insurance is almost a guarantee you're not going to die. I've been paying for 35 years on a policy with the Knights of Columbus. I've had disability insurance since I was 27 years old, and I think they guaranteed I never got disabled. And even though I'm over 60 now, I'm afraid to cancel a disability policy because I'm afraid I'm going to get disabled the next day. As I mentioned with the living will, there's also a clause where you're going to indicate organ donation yes or organ donation no. I recommend everyone sign the organ donation part. There is a document not a document, but some people do what's called a letter of instruction. It's not in lieu of this. It's more where you're just preparing something helpful for the family. It's not a legal document, but you're going to say, okay, listen, my financial, so they don't have to go through every, right away, every scrap of paper to try to say, okay, listen, my financial advisor is this person, my attorney is this person, my accountant is this person. Many people, more and more people are pre-planning, even prepaying for funeral. I said, listen, if I pass away, I want to, have a big party at the Elks Club, open bar, lots of sandwiches and food, nothing fancy in a restaurant where you got to sit down and wait to be served. I want it to be a party. I want it to be a celebration. And everyone can bring home some of my track trophies from college as a souvenir. One of our little old lady clients, she wrote her letter of instruction. She put down no funeral, no wake, no mass. And I go, why? She goes, I'm almost 90 years old. Everyone I was friends with, they're all gone. I don't want people to feel obligated, and and I kind of agree with her. In a way, I'm a Catholic guy, but the Mass is so sad with sad music. A celebration of life is a little bit more fun. So let's see. Don't be a putter off or get the things done. By the way, in a way, I'm reluctant to send out information because, and then people goes, I want to read more up on it. Don't wait. Get things done. I'm gonna put my website and contact information in the chat button. But I thank everyone for listening today. My name is Ken Vercammen, and I'm an attorney in Edison. I live in South Brunswick, and I've been in this area for a lot of years. Thank you.